Hi, everyone. Sorry about the delay here. This is Monica with the Best Interest of the Parent. We just had some internet challenges, so I had to reroute to a new network, but it looks like we're fine now. So thanks for being patient. And we are here this week for a Q&A session. And it's exciting because I sent out an email and I said, tell me the questions that you have. And I got some responses. Let me just adjust my settings here. Okay, let's try that. Okay, let me try. I'm just trying to brighten up my screen a little bit. It's kind of shadowy. So, excellent. Hello, glad you're here. Thanks for saying hi. So we have 4 questions today. And next week, we're going to be talking about Micheline Epstein's case. This is the doctor out of Brooklyn who had her daughter taken from her for not wearing a mask outside of the school. I don't know if you've heard of that case. It's linked in the group. I'll link it again if needed, but this mommy is in the group and she and I have been in touch. Sadie, I'm doing my recording.
Why is this marker so lighty?
I don't know. I don't know, baby. I think it's special. So we're gonna be talking about her case next week, and eventually we're probably gonna interview her, but we're waiting until the nastiness is over with her case before she comes on. But I want her case to be more public. I want everybody to be talking about this. And when we have these cases that have a lot of attention, then that's unfortunately that's the kind of stuff that gets the attention of lawmakers. You know, things like the George Floyd situation and the big headline stories can facilitate change. And it's unfortunate that we have to have such extreme things happen. You know, apparently it's not good enough that 20 million parents are walking around without their kids every single day. And it's not good enough that for 50 years, fathers have been separated from their children. And now we're seeing mothers being separated from their children. Over the past 15 years or so, we've been seeing the same sort of abuse with mothers as we have with fathers. So apparently that's not enough to bring on change. We have to have these giant headline stories, these outrageous stories to bring on awareness. But we're gonna roll with it because that's apparently what it takes. So the questions I have, these came in order. So we're just going to get right into the Q&A, all right? We're going to skip the introductions. You guys probably all know who I am by now. So, all right. So the first question that came in is, so this was like a longer question, so I typically summarize whenever the question comes in several paragraphs. So don't take offense if I don't read your question word for word, but basically there's a mom that is in the process of getting a divorce. And she is, the kids are scared of the dad. Okay, dad lives 6 hours away. Kids are scared of the dad. Mom wants sole custody. Mom wants, sole legal custody, sole physical. So, and this is an unusual question because typically the parents that I work with, well, that's actually not true. Well, yeah, no, the majority of the parents I work with have already had their kids taken, or they've already faced a lot of corruption in their case. They've already lost something. So, and then there's a percentage of parents who haven't lost anything yet. They're in the very beginning of the process. And interestingly, even though I don't get a lot of parents in that position reaching out to me, they're ironically the ones with the most success. The parents who are not yet divorced have almost 100% success working with me, which is really funny because it's like I focus on the parents who've already lost. And I had a student last summer who took my course. She wasn't even divorced yet. She took my course. She only got like 5 weeks into the course and she stopped participating in the course. And the reason for that was because she got her entire court case was closed. Like she was done. She finished her divorce. Everything was fine. There was no reason to continue taking my course. Like she hadn't yet gone through all the trauma and chaos. So I thought that was really cool. So I was like, all right, well, if you got what you needed in the first 5 weeks, then awesome. But unfortunately, that's not the situation with everybody. Most people have to go through the entire course to get the full results. So anyway, so this mom has not yet even approached court, but she wants sole custody, sole legal, sole physical because the kids are afraid of the father. And there was abuse. I asked, I said, was there abuse? Yes, there was. She outlined, the situations. Now, the problem in this situation is that she didn't call the police on the father when the father was abusing the kids. And now the reason a lot of parents don't call the police is because if they do, the police will come and have both parents arrested, possibly, or the police will automatically put a call into CPS. CPS gets involved, and then as a measure, CPS typically will substantiate both parents when one parent is abusing. So if you're married and your spouse is hurting your children, whether you're a man or a woman, who, gender is non-issue here, and you call the police on your spouse, a lot of parents find both of them in trouble when only one parent is the offender. And so especially in blue states like Connecticut, where I live, California, and other like New York, I'd say like those 3 states, probably Rhode Island, probably Massachusetts. And yeah, it's like those 5 states are very, very, very blue nanny states. So whenever a parent is asking for government help, the government will give more help than what the parent is asking for. And they get overly involved, and they want to insert services into that family, and they want to just create chaos and problems for the family. So a lot of parents will just let the abuse happen because they figure it's better to just deal with the abuse than deal with the government coming after me and trying to punish me for something I had no control over. So anyway, that was likely the situation why mom didn't make police reports. So therefore, she doesn't have a chain of evidence to show that dad was actually being abusive. The only thing she has is what the kids are saying. And as you know, if the kids are reporting abuse, even though we encourage kids to report abuse, we all know that when kids report abuse in the family court system, they're not believed. The kids are likely just thrown into therapy, and likely the parent who's not hurting the kids is going to be accused of brainwashing. That's just what happens in family court. So it's only really beneficial to call the police and have an actual arrest, have a conviction, have a plea bargain of some sort, probation, jail time. Like if none of those things have ever happened in the family, and then the parents are divorcing and one parent wants sole custody because there's abuse, it's a shit show, right? Like you guys all know this, right? Anyone who's been in the system. Now, this parent has not yet entered the system. So she asked for advice, she asked a question. And so what I'm going to say to you, and this is just based on my experience, what's going to happen is if you can't go to criminal court to have formal charges filed because there's no evidence, or the police won't take a report because there's no evidence, and oftentimes the kids won't report the abuse to the authorities. Like the authorities will yank the kid into a room and try to get the child to explain the abuse. And now I was an abused child. I had the police called on my parents for abuse, and I would not rat out my parents. Okay. So I know what it's like to not want to tell anyone that you're being abused. I had school social workers asking me if I was being abused, and I'm like, yes, I am. But of course I would never have said that. Like, why would I freaking tell on my parents and then go home 2 hours later and then they find out that I told on them. So I was never told that I would be safe if I told on my parents. Like no one ever said it's okay to tell on your parents, you're going to have safety. Like no one promised me that. So why would I tell on my parents? So this probably hasn't changed. I mean, the system has not changed in 30 years since I was a kid. So that's probably why kids aren't really reporting abuse, because there's no guarantee that the kids will be protected, because they're not protected, right? So the safest thing they could do is just to be quiet, because they're familiar with the abuse. They're familiar with the chaos that they're experiencing. So why would they invite something unknown into their lives by telling on their parent and possibly creating more problems? So anyway, I'm taking a really long time with this question, but that's okay. So what I said to this parent, I said, if there's no like arrests, if there's no convictions, plea bargains, probation, any sort of police activity, and or like, bona fide witnesses. What, sweetheart?
Can I play the phone a bit?
Yes, I'm letting my daughter play with my phone. All right, hang on.
And my name's Sadie.
Your name's Sadie? How old are you, Sadie?
5.
Okay. I'm going to turn the music on, but you can't turn it up loud, okay?
Okay.
Okay. She has like a strawberry shortcake game that she plays on there. So if there's not police activity that can be corroborated with like actual police officers testifying and stuff. But again, there should have been a conviction in criminal court. Like if you have enough evidence to take to the police, then you should just go to the police. Don't like if it's kind of a catch-22. If you have enough evidence to get the family court to take your side, then you should go to the police. Does that make sense? So if you have the evidence, go to the police, don't go to civil court. That's just my personal 2 cents. I do not believe in privatizing safety. I testified in a public hearing a couple weeks ago. I'm going to turn this down, sweetheart. Give it to me. It's too loud. I testified in a public hearing 2 weeks ago about this very thing, where they're trying to pass some new laws in Connecticut where family court takes over abuse, you know. And I testified against this bill. I said parents should not be going to family court to ask for safety. You don't privatize safety. You shouldn't have to pay for safety, because the parent is going to be forced to hire a private attorney, possibly get a private GAL for the kids, get the kids into private therapy to investigate the abuse, something like that. Like, as citizens, we should all be able to go to the police if we're being harmed, whether we have money to pay for an attorney or not. Like, the way this law is being constructed in Connecticut right now is that people will be forced to hire private attorneys to protect themselves from danger. And that's ridiculous, because what if you're poor? If you're poor, you can't afford to hire an attorney to protect you from safety or from danger. So everybody should be able to call the police and say, I'm not safe. My kids aren't safe, blah, blah, blah. And then the police should do a full investigation. But what happens is police are dumping things into family court where people have to pay for safety. Anyway, so in this case, mom has no evidence, no verifiable proof. It's just, you know, so she wants sole custody. So what I'm going to say is that the only way you're going to be able to do this, you can't use constitutional rights to get sole custody, because the whole premise of constitutional rights is that we're all equal under the eyes of the law. We all have equal protections under the 14th Amendment. And if you have constitutional rights, then so does your children's father. Does that make sense? So you can't really fight it with constitutional rights, because those same rights apply to the other parent, who is the offending parent, who's actually hurting your children. So the constitutional rights actually help your ex, because he could use them and keep the kids. And if he's abusing them, he could continue to do that. So you're going to, unfortunately, and this is just my opinion, my interpretation of the law, you're going to have to unfortunately ask the judge to make a judgment call, AKA best interest, and hope that the system isn't corrupt and isn't going to place the kids with the abuser. And I mean, you know, I don't know if there's like domestic violence help in your state. The domestic violence network in Connecticut has a ton of funding, tons and tons of money, tons of resources, tons of connections, and they don't do anything for parents in family court. They're completely useless. I don't know what they do. I think they just put out publications, and they probably deal with safe houses and stuff like that. But again, like, these safe houses are also dangerous, because they have CPS social workers coming into safe houses and trying to get help for the battered woman, which it means the kids start to go through CPS. But I'm getting off on a tangent. If anyone knows about their domestic violence network in their state, let me know, because I get a lot of questions about this. And my interpretation, from what I've seen, the domestic violence networks will help the parent, but they'll help the parent by giving them a lot of government services, which means that your kids will have a lot of oversight and be tracked, monitored. And it's just, you're kind of trading your freedoms for that. And I don't know. I mean, I truly believe in just using the criminal system to prosecute, instead of getting services that aren't going to protect. I don't know. I don't know enough about these networks to say anything bad about them. I do know that they don't help parents in family court. I can't tell you how many parents have contacted me saying that the domestic violence institutions don't help. I think they're all connected. You know, the Attorney General, who oversees family courts, also works very closely with the domestic violence networks. And it's like a conflict of interest. It's like if there's not, if you're doing too good of a job in family court, you know, overseeing the family courts, you're going to kind of cause jobs to be lost in the domestic violence industry. It's kind of like, the more chaos you can promote in the family court, the more jobs you could open up in the domestic violence in the government services. Like, it's just, there's just no incentive to making the courts function well, because then the services that are I don't know. I just feel like the whole thing is a gigantic conflict of interest, and I don't know enough about domestic violence shelters to be able to speak about it. So, in your case, you're going to have to just present your story to the judge. And I mean, what I would do is, while I'm presenting my story to the judge, I would ask for protections. I would say, I don't want the judge to, because you want to protect yourself from losing your kids. You want to protect yourself from having the kids taken out of your home and put into the abuser's home, because that's what happens all the time. I'm just going by what I've seen. I'm going by what the statistics are. I'm going by what all these research papers say. Whether you're a man or a woman, if you're abusing the kids, you're more likely to have the kids. It's not a woman versus man thing. It's like, if you're abusing the kids, you're going to have a leg up in the system, period. The system promotes abuse. I'm just going to light a candle here on that note. So, and I don't make the facts. I just report the facts. So until that changes, that's what I'm going to be continuing to say. So I want you all to see the candle. So I'm going to do that. So get the full experience, internet candlelight. So so you're going to have to present your case to the judge and just hope that they don't F it up, and ask for protections. Ask that you don't lose your kids. Like, we have to ask for this shit. Apparently we have to ask the government to not take our kids away. So when you're presenting, just really focus on protecting your own rights at the same time. Often when there's victims, they tend to, unfortunately, outsource all their power to the state. And that's kind of a side effect of being abused for a long period of time by your partner. So, we kind of get very dependent on the resources that we think are going to help us. So keep yourself grounded in your rights, even though you have to ask the judge to make a best interest of the child determination. I'm going to get to the comments on this, because you guys probably know more about this than me. I don't know a whole lot about domestic violence. I just know that they don't do anything to freaking help parents in the court system at all, especially if you're a man. I think they're useless, to be honest, at least in my state of Connecticut. So let's just see what this one parent said here. We're there. He has 2 strangulation convictions. The court ignored all of it. We've had CPS and Mike's, DYFS. The children have divulged abuse numerous times. However, father said he didn't do it. So they have closed 5 investigations. Family court has ignored everything. And I'm in contempt for keeping our children safe. Oh my God. This is exactly what I'm talking about over and over again. Abuser is looking to incarcerate me for protecting our children. Yeah. All the time. All the time. I see this all the time. Go to Cocoon Shelter and you'll get a free lawyer to handle this for you. Okay, that's really good. So the lawyer, I've never seen a domestic violence lawyer ever help a parent in Connecticut. And Connecticut gets a lot of funding. Like, we're a very blue state, and we have nothing. We have nothing to help parents. So I'm very curious about that system that you have. The parent who talked about the Cocoon Shelter, if you want to share more about how that works, I'm very curious. Like, I know very little about that subject matter. So yeah, you're going to have to just ask for the judge to make an opinion. Personally, I'm very much against evaluations, guardians ad litem, all that stuff, because here's the thing. If you're trying to protect your kids from abuse, and you have a guardian ad litem coming in to interview you, interview the kids, interview the teachers, the freaking doctor, all these people, A, that's a lot of money. And B, even if 20 people tell the guardian ad litem, yes, the kids are abused, the guardian ad litem still gets to formulate their own opinion on all this. And they get to decide what happens. Like, it's discretionary. Apparently, safety is discretionary in family court, okay? In criminal court, safety is not an option. Like, if you hurt somebody, you're going to be punished. In family court, it's discretionary to keep someone safe. So the GAL, the guardian ad litem, or the evaluator, whoever you bring in, the therapist, they will use their own opinions. They'll be like, okay, well, yeah, maybe the kid had, black and blue marks and stuff, but the dad said he was sorry, or the mom said she was sorry. And, they get to have an opinion, and then they get to present that opinion to the judge, and the judge gets to choose. So they're not bound to any laws. I've never seen a guardian ad litem be like, oh my God, I'm going to call the police and report this. They're not even mandated reporters in the state of Connecticut. if your guardian ad litem is a mandated reporter in your state, please tell me, because I'm still looking for evidence that they have to report crimes. From what, if you're a teacher and a kid's saying I'm being abused, you have to call the police. Guardians ad litems have no rules on doing those things in my state. So, okay, so someone says here, if you're going to best interest of the parent, document, record everything if it's a one-party state. Yes. So my candle went out. That's weird. So,
Can you help me, Mom?
okay, hang on, baby. So I trash the best interest of the child standard all the time. I always say it's like the crappiest thing in the world, don't ever do that. It's a waiver of rights, blah, blah, blah. But sometimes we have no choice, because sometimes constitutional rights aren't the best thing. Like if you're trying to prove abuse, there's not really much constitutionality you could apply, because it applies to the offender as well. Baby, go take your thing. Go take your game. So we had an agreement that she'd be quiet. Okay. So sometimes you have to use best interest of the child. Like, you just have no choice. So yeah, so you have no choice but to create documentation, or not go to court at all, and see if you could sit in the situation that you're in. There's nothing wrong with not doing anything. Sometimes, like me, I'm not going to court right now for my son. My strategy right now is to do nothing in the court system and just deal with what I have. So that's my strategy right now. So there's really no right or wrong way. I personally think the best way is constitutional rights, all the time, like 99% of the time. So back to this question. So if you're being encouraged to get a guardian ad litem, an evaluator, understand that they get to use their own personal opinions. They don't have to weigh evidence. They don't have to check up on resources. They don't have to do anything. They literally don't have to do a single thing. And so if you're going to do that, again, protect your rights the whole way. So if you get an evaluator, they're going to want to know your mental health history, you as the non-offender, your family history, your employment history, your medical history, your job history, how many places have you lived? My evaluator wanted to know my college grade point average, and I told her, and she called UConn to verify, and UConn verified, and then she used that against me. I had a 2.9 GPA, which is like a B minus, just under, like it's like an 82, on the scale of 1 to 100. And that was like a big problem in court, my freaking grade point average. She was trying to say that I didn't have any job prospects. Clearly I don't, I'm not running a Facebook group right now. So, so again, everything you say to the evaluator, you might think it's innocent. Like, you might be like, oh, I have a stepbrother. I mean, this was used against me. I have a half brother from my mom's second marriage, and then I have a half sister from my mom's third marriage. That was used against me in court. Apparently it's my fault that my mom had a baby when I was 6 and had another baby when I was 10. Okay. with two different husbands. So that was used against me. I have a bad family life and all this shit. Right. So anything you say, you could say, I had a mom from Alaska talk to an evaluator once, and she was talking about her Alaskan heritage and how, like, they fought for the land that they're on, and they faced a lot of racism and discrimination in like the 40s and 50s and stuff. And that was used against her. And in fact, she had her child completely taken away from her. So anything, your history, your lineage, like everything could be used against you. So I would not agree to any of those evaluations. I would say, can you just narrow the evaluation to the abuse aspect instead of me as a parent? I think my internet is going to crap right now, so I apologize. So I'm going to move forward to the next question. So
This is the best.
let's see here. And I don't know if I'm being recorded right now. Can someone let me know if you could see me talking? Because I have no internet, apparently, according to this. All right. Yeah, no one's responding, so I probably don't have a signal, which really sucks. So, Sadie, you got to keep it down, baby, okay? All right. It looks like I'm getting some internet now. I don't know. That really... so someone says, you talking. Oh, someone said yes. Yay. Okay. See you talking. I was like, all right. So anyway, Sadie, keep it down, honey. Okay.
Yeah.
So, okay, we're going to go on to the next question. And this is actually really convenient because this next question kind of ties into the first question a little bit. There's some overlap. This is, God, when I see this, it just drives me crazy. So this parent says, I said no to therapy. Okay, so the court wanted mom and dad to go to high conflict co-parenting therapy. The judge ordered it. The parent spoke up and said, I don't want to do co-parenting therapy because I can't afford it. Okay. And the parent was like, I have a slam dunk argument. I can't afford it, And so what happened? The judge appointed a free co-parenting counselor through the court system. Yay. I love free therapy through the court system. Like, thank God, now I'm going to handle all my problems. My ex and I are just going to get to the bottom of all our issues thanks to this free government service. Like, thank God, we're finally going to get all the problems fixed. So this is the problem. So now there's a court order. This court order is issued 2 months ago. So February, March, April. So 2 months, So there's now an order that these parents have to go to co-parenting therapy, and it's a free therapist. So this is a problem. There's a lot of problems with this. So when a parent objects, and they do this, you guys do this all the time, and it seems like a good objection, doesn't it? Like, hey, I can't afford it. I freaking have $20 in my bank account. I can't afford it. Like, you guys feel like that's such a great argument. And it seems like logically that is a phenomenal argument. Okay. Like, you go to the store, there's a $100 shirt, you only have $20. It's logical that you can't buy it, right? Like, no one's going to force you to buy it. When you're in court and you say, I can't afford something, don't ever say that, because then the government will give it to you for free and then you're stuck. Okay. When you say I can't afford it, you're not using any rights. There's no rights. Like, you're not applying anything substantial, or substantive is a better word. And so the government can fix that by giving you a free therapist, and they're worse, because the free people, when you're getting a free therapist or a free guardian ad litem or a free evaluator, whenever someone's working for free, and I'm not against free services. Like, look, if you're a young single parent and you need food stamps, go for it. Like, I'm a libertarian, but I'm totally about getting kids fed. Like, I don't care about food stamps. I don't care if my tax dollars pay for that. Housing assistance, heating assistance, all that stuff. Fine. It's fine. What I'm saying is whenever you're getting a service for free, it eliminates like the market competition. I'm not an economist, or whatever that word is, economic person, economicist, whatever, economist. That's none of those are words. When you're getting something for free, there's no market, there's no incentive to compete with the market. So no one has an incentive to give out a good product. So I charge for my services, and I have an incentive to give out a good service, because if you guys don't like me, you're going to go find somebody else. Okay. That's what keeps people like me accountable and keeps me doing ethical things and keeps me sharpening up my skills so that I'm constantly giving you guys good quality content and stuff like that. If I was free, if somebody else paid my salary and I just had to give out some shitty service to the public, what incentive do I have to do a good job? The government's paying my salary. Joe Schmo that I work with and his ex-wife, Jane Doe, like, I have no incentive to do good work. Like, and if they complain about me, who cares? Like, they're just assholes who can't get along, right? They're just idiot parents who can't figure out their stuff. And so a free therapist is worse than a paid therapist for that reason. They're not going to give out any quality service. And also it's a waiver of rights, because now, especially if the state is paying for this service, does the state get to have access to your documents, your session notes? Is there any confidentiality involved? Is there like, can you sue that person? If that person is a state therapist, do they have liability insurance? Are they bound to the same licensing laws as a regular private therapist? They probably have immunity. So if a judge is injecting somebody into your life and saying, now you have to work with this person, Dr. So-and-so, the judge might confer immunity onto that person, which means you can't sue them if they screw up. So there's a lot of problems with free services. And I had a client in 2019 who got involved with DCF for like a long time. DCF is basically CPS in Connecticut. And it started with her geting WIC. So she was getting like $40 a week of free formula. Okay. And that's great if you need to feed your baby. But what happens is when you get the free formula, you have to submit to like weighing the baby. They check the baby's weight, height. And it's like, these are freaking WIC people. Okay. Like I have a nutrition degree. I could work for WIC if I want to. And I'm not qualified to decide if a baby weighs enough. Like I'm not a doctor. And so what the WIC people were doing is they were weighing the baby, measuring the baby. And if the baby fell like below a certain percentage, they had to call DCF. And so when you're getting a free service, find out what you're giving up to get that free service. So read the fine print of the contract you signed. Hopefully you signed a contract. Most of the time in family court, I see parents not signing contracts. Like these people don't even know what a contract is. Like these professionals don't even issue contracts. It's like, I'm your therapist. Let's get started. I'm your guardian ad litem. Let's get started. It's like, there's no freaking paper trail or paperwork or contract. It's freaking scary. Right. And so if you have a contract, which I hope you do, read the fine print, find out what the terms are. I mean, how long do you have to work with this person? What if you want to quit? Do you have to ask the freaking mommy and daddy judge to get permission to quit therapy? Find out if your rights under informed consent apply. Find out if the patient's bill of rights apply. Find out if that therapist is bound to laws under the American Psychiatry Association, psychiatric APA. Read all the fine print. And so most likely the reason you said I can't afford this is because you just didn't want to do it. And you also can't afford it, but also the thought of going to therapy with your ex probably makes you sick. So what parents will do is they'll hinge on the financial piece instead of hinging on the fact that, hey, it's really bad for my health to go to therapy with this person. You know, if I go to therapy with this person, it's going to aggravate my mental state. Like then when you say something like that, you're legally protected. You're legally protected from having to further harm your health by going into this service. So if you say something like, Your Honor, if I go to therapy with this person, it's first of all, I don't consent. It's not good for me. You could say it. I mean, you could say, I'm not telling you what to do. I'm not a lawyer. Talk to your lawyer about this. Your lawyer is probably going to tell you to agree. I think parents should hire civil rights attorneys and not family law attorneys anytime they have a divorce. If you're married and your ex serves you for divorce, hire a civil rights attorney. Don't even freaking go to a family law attorney. I'm just kidding. You should really hire a civil rights attorney. And see if they'll go into the bowels of family law with you. You know, they might charge you double for dealing with that, but you're better off using your rights to get out of a forced co-parenting therapy session than say that you don't have money, because now you're stuck with a free therapist. So, I mean, if you're 2 months in and you can't appeal the order, I mean, what probably happened in your case was that the judge made like a bench order. How does that work? Yeah, the judge probably made a quick off the cuff order. Okay, here's a question. Who filed the motion? Did your ex file a motion for therapy? And oh my God, if your ex didn't file a motion asking for co-parenting therapy and the judge just issued it just because they freaking felt like it, then the judge is making an order that wasn't, where no one filed a motion to get that order. So it's like a bench order. In most states, I'm 99% sure you can't do that. Someone has to ask for something. The judge can't just give an order without prior, without someone having filed a motion, because then you did not get an opportunity to procure an argument, which is probably why you said I can't afford it. Because I'm sure if you found out days and days and days in advance, you probably could have come up with something better than saying that you can't afford it. Because I know you've been following me a long time. I think you've been following me for about a year. So you know I'm against all this stuff. But you probably didn't have enough notice that you were going to have to fight that. And that's probably why you said, hey, I can't afford it. Because that's usually what parents say when they're panicking. And they're like, oh my God, that's a lot of money, you know. So if your ex didn't file a motion and the judge is just trying to play daddy and give you therapy, you might be able to vacate that order. So I would talk to an attorney and say, look, I was ordered into therapy against my consent. I tried to say no. The judge ordered it anyway, and my ex didn't even ask for it. Is there a way I can get out of this? Because there was relief not requested granted. In Connecticut, we call it relief not requested. That could be a term in your state as well. So talk to a lawyer. Yeah, someone says sua sponte. Sua sponte is the same thing as a bench order. So if a sua sponte, that's actually a better term. A sua sponte order, if you don't get if you're not given any advance notice that a judge is going to say that, then how can you possibly procure an argument? Like, what do you have? 12 seconds to say something? Like, that's not enough time. You need like 12 days to come up with something so you can research your case law, your statutes, your rights under informed consent. I mean, you can't be forced into therapy. You can't. Like, we don't do that anymore, right? I mean, there's a lot of cases out there that say that you can't do that. O'Connor versus Donaldson is a good case. It's not exactly tailored to your situation, but it's a good case that outlines that government can't take over our welfare. Like, government can't come in and say, you need this therapy, you need that therapy. Like, we as people of sound mind have to be the person that's in charge of our own health and welfare. So yeah, so that's the answer to that question. Gosh, but yeah, be careful of free stuff, guys. Like, free stuff is worse than the paid stuff, and it's done on purpose. Like, free stuff is really valuable to the state because then they get to like have data, they get to like report that data, they get to collect money, they get to ask the federal government for more funding because, like, oh, look at all the parents that have to get free therapy, and then they get to ask the government for more money. So they're actually creating more lucrative income for themselves by giving this free stuff out. It's not a charity. It's not like a nonprofit association to the court system. So that's the second question. I think did I lose one of the questions? I feel like I had 4 questions and I can't. Oh, okay. Never mind. Okay. So we're going to go into the next question here. And so I'm going to kind of call out this parent lovingly because I want, and this is so helpful. And if someone had told me this early on, I would have been so grateful. But this parent started off the question saying that they were given joint custody. Okay, so here's the problem with the word when parents say I was given joint custody, the way we talk, the way the words we choose have a very direct impact on how we think, and then as a result, it impacts how we feel, what we believe, and then it impacts how we behave. Okay, so let me simplify that. When someone says I was given joint custody, you can't ever be given joint custody. You already have joint custody. The minute your baby's born, you have joint custody. The minute your baby is born, providing you're not an unmarried father. Okay, that's a whole nother thing. But if you're female and or married, okay, you automatically have joint custody of your child. So you can't ever go to court and be given joint custody. Your custody can only be taken away and then restored later on, if you jump through enough hoops and make the judge like you. But in the very beginning stages of your divorce, you're never really given joint custody. So the only reason I'm calling you out on that is because parents always say that. And I said that all the time. I would say something like, I asked for joint custody. I requested joint custody. I would say things like that all the time. And then it impacted like how I wired my thoughts. And we really need to flip the script and be like, no, we're never given custody. Custody can only be taken away. It can never be given. Custody can never be given. It can be given back after they take it away from you, but you can never be given custody ever. And men do this. Men are worse than women. Men will say like, oh, she gave me every other weekend. She gave me, April vacation. What, sweetheart? Yep. So anyway, we're going to get to the actual question. So yeah, you weren't given joint custody. You got to keep joint custody. I kept my joint custody. That's a better term. So anyway, long story short, with this parent, she has not picked up her kids. And I'm so sorry if I'm skipping some details because I tend to not use the entire question when I answer. How do I get this changed? She wants to get her son from school. And she hasn't picked up her son in a very long time from school. I think she said it was 2.5 years, something like that, maybe longer. Long story short, she wants to get her son from school. I feel you. I haven't taken my son to school in so long. I don't even remember the last time I took my son to school. I do get to pick him up from school, though. Thank you, Judge, for letting me pick up my own child from school. once a week. So we have here the mom asked to have that restored, apparently, that she wanted to be able to pick up her son from school. The judge said no. No reason was given. Okay. The judge has had a motion for reconsideration for 4 weeks now. So that means that her lawyer submitted a second request saying, can you reconsider our request that she pick up the child from school? And there's been no answer. So here's the question for you. What legal basis did your attorney use to get your child from school? And I believe part of this request was a hearing to get additional time with her son, her 14-year-old. My son's 14 too, so I get it. It's tough. It's really tough to not spend enough time with our teenagers. That's when they need us the most. Like teenagers and toddlers, like they need their parents. I've had nothing but stalling tactics, false accusations from opposing counsel. I'm not allowed to get my son after school. When I asked if I could get him from school, blah, blah, blah. Not that you're saying blah, blah, blah. That's just what I say in my head. How do I get this changed? I don't understand why I can't get him after school. Is this a losing battle? So the question is, what legal basis did your attorney use to get your son from school? And most likely your attorney, and you said we had a very strong motion. So any advice on what to do next regarding the judge, opposing counsel? I'm beyond frustrated with all this. 3 years. Yeah. So it's been 3 years. So what legal basis did your attorney use? Did the attorney ask for a judge to make a best interest of the child determination? Most likely the attorney did, and the judge just simply didn't buy the story, basically. And so if I were to do a redo, if I were an attorney, which I'm not, but if I were in your shoes and or if I were your attorney, I would have said that parents have a fundamental right to raise their children as they see fit without government interference. And they also have a right to do that without interference from other parties like your ex. You know, your ex doesn't have the right to interfere with your parental rights. And I'm probably guessing that your attorney didn't use that argument. Most attorneys don't. They'll instead say, well, mom's schedule does this and dad's schedule does that. And they're using logic to appease to the judge's whims, basically, appeasing to the judge's temperament. And most attorneys play that game. They don't use law. They use appeasing to the judge's temperament. And if the judge chooses to have a conniption fit over the concept of you picking up your son from school, then they're legally within their authority to do whatever the hell they want, because they were asked to produce a best interest of the child opinion. And so what I would do unfortunately, since you've just had a ruling in February, according to you, for 4 weeks now, so, last month, it's going to be hard to go back and file a motion to modify, but you might have to wait until there's a change in circumstances, which takes a while. So you can refile the whole thing, ask for equal custody if you haven't already, and use your rights to lead your case, like lead with your rights. Like say, I have the right to do this. I have the right to parent my child without government interference. And I have the right to parent my child even though my ex doesn't like me. Okay. Because not being liked by another parent has zero bearing on your First Amendment rights to family integrity, keeping your family intact. And your family includes you and your son. It doesn't include other people, necessarily. It could be just you and your son. The definition of family, the legal definition of family, encompasses a lot of variables. And so you have the right to family integrity. And if the state isn't letting you pick up your own child from school, you are your relationship with your child is being interfered with, and you have the right to not have that. And so, if I were you or your attorney, I would create that argument instead of asking for the judge's opinion of your child's best interest. Because your judge could say, it's been 3 years since he was picked up by his mom. He's not used to getting picked up by his mom. So we're just going to let him be picked up by dad forever. My judge for like 11, for all these years has always said, this is what the child is used to. We're not going to upset his schedule by inserting mom back into his life. Now that's a best interest of the child opinion. A judge can opine that it's not good to disrupt a child's routine by suddenly introducing his mom back into his life. So even though So that's because I was asking the judge for their opinion. I was saying, it's in my son's best interest that he sees me more. What do you think? That's basically what I was doing, or my attorney rather. That's how I crafted my legal arguments the first 5 years of my case. Was my son needs me, kids need their mother. We have a good relationship. I want to keep that relationship strong. What do you think, judge? And the judge says, no, I'm not going to upset his routine. Boom, I lost my case. And so what I did in 2015 is I came back and I said, excuse me, I have a constitutional right to raise my son without government interference. And I took that all the way to the Connecticut Supreme Court. So I think parents should fight like that instead of asking for an opinion. So you're fairly new to best interest of the parent. So people have been following me a long time know that I say that over and over again. This is just what I would do. I'm not an attorney. This is just the thought process I have. And I don't think best interest works. Like, if best interest worked, why do we have so many motherless and fatherless children walking around every day? Why do we have freaking, teen pregnancies and teen suicides and gangs and drugs and kids dropping out of school? And they always say, like, the number one risk factor is missing out on a parent, typically fatherlessness, but motherlessness will do that too. So I would lead with your rights. And if you can file a motion to modify for equal custody, I would do that. So I don't know if that's the strategy your attorney used. If they did use that strategy and the judge isn't giving you the equality, or restoring your rights, then I would appeal. I would freaking appeal, because you have a legal basis to appeal. You can't appeal a best interest of the child determination. These appeals courts will always come back and say, no, the judge gets to do whatever they want. It's the judge's best interest, So that's the answer to the third question. I know it sucks. I haven't picked up my son. I haven't taken my son to school in so long. So let me go to the final question. And this question came actually as a YouTube comment, and I was like, whoa, this is amazing. So, and I won't spend a lot of time on this comment because it's a little bit redundant on what I've already been saying for 45 minutes. So let me pull that up. But I thought it was pretty fascinating. I believe this comment came in like today or a couple days ago. Whoops, let's not do that. Okay, so oh gosh, like, wait till you hear this, guys. If you haven't seen it all, yeah. So long story short, a mom was talking to I think it was a mom. Yeah, mom was talking to a social worker. I don't know why. She just was. My opinion, I would not talk to social workers. There's no benefit unless okay, let me rewind. There's no benefit in talking to a social worker unless you think you have some challenges and you want help. Like, I'm all about rehabilitation. If you have an anger problem, you want to talk to a social worker, yes, do it. If you have a housing problem, you want to talk to a social worker. Alcohol problem, drug problem, gambling problem. I'm all about working with social workers if you want to. If you feel like you need the help, go do that. Absolutely. I think social workers are great. I have a lot of friends that are social workers. So what I'm not in favor of is a social worker being injected into your life and you don't want that person in your life. Okay. So, but I don't know why this social worker was in the picture, but the social worker said, what is your family strength? Guys, that's a freaking trick question. So the mom said, I've been in recovery 10 years. Now that's a great thing, right? Like 99% of people would think that's a great thing. I think that's awesome. Right. And because of that response, the mom was subject to weekly random drug screens, on and on and on, substance abuse evaluations. The social worker listed the service as a service provided to the parent. So now the parent has to pay for that service. So not long story short, the mom inadvertently got herself into a case plan, a service plan with, I believe it was CPS. It looks like CPS because they said social worker, but I could be wrong. The services were not needed or not applicable, and the parent has to foot the bill. There were far more applicable services that the family could have utilized, like housing. Because alcoholism and addiction are covered under the ADA, wouldn't this be some kind of discrimination against a person with this disability? Sorry about the spelling and grammar. There was actually no spelling issues in there. So, so does the American with Disabilities Act cover alcoholism? Where is it? Alcoholism and addiction. Okay. So that's actually a really good question. I do have training. I am a trained ADA advocate. So I don't know if alcoholism and addiction are covered, okay, which is really stupid. I would check with like a civil rights attorney on that. So the answer is I don't know, but I would talk to a civil rights attorney about the fact that that this social worker maybe overstepped her bounds or something like that. And like the mom didn't have an advocate present when she was being interviewed by the social worker to help break down the long story. Here's the answer. Don't talk to a social worker without an attorney who could break down how to answer those questions while protecting your rights at the same time. Because most of the time in DCF cases, the parents kind of give the key to the state to come into the case and start doing bad things. And I don't know if addiction, I know that there's like side effects that are covered. Like if you have like neuropathy because of your addiction, or lung problems because of your addiction, or if you can't walk very well because of your addiction, like let's just say that whatever the case may be, you took too many drugs or something and it caused like some temporary paralysis and you can't walk. Like I know that like if it impacts an activity of daily living, it is covered, but I don't know if the actual condition itself is covered under the American with Disabilities Act. And unfortunately, if you had the same behavior, so this is the thing. Addictions they could cause violence. They can cause you to be forgetful. They could cause you to not be able to operate machinery very well. So those are safety issues. So they really should be going after the parent's conduct instead of the parent's condition. So if this parent has an attorney, which I hope they do, see if the attorney could ask that, ask for a list of formal charges for one thing. This is just what I would do, not legal advice. Ask for a list of formal charges and ask for a list of charges on the parent's conduct, not on a condition, okay? So a condition is not punishable, but someone's poor conduct is. So if you're an alcoholic and you never hurt anybody in your life, that's legal. You're legally allowed to be an alcoholic. And so it's only when there's conduct that is illegal that is punishable. So find out if this parent here has any punishable conduct in the past, whatever the statute of limitations are, ask for a formal list of charges. If she's been clean for 10 years, they would literally have to go back to prior to 10 years and retroactively file charges. And I don't think they could even do that. So I would get this parent's attorney to focus on conduct, poor conduct, dangerous conduct, abuse, rather than a condition. Whether or not it's covered under the ADA, I don't know. I would almost say, I almost want to say it's not, and it should be, but it's not, I don't think it is. So that wraps up the Q&A. Of course, I picked a really complicated question to wrap it up, but I love questions like that. Like it's just, ugh. So let's see what we have here in the comments. Let's see if we have time to address any of these. Okay. All right. Okay. All right. So we have a parent that says, I'm on my third attorney. This one's finally fighting for us. That's really cool. So I'm laughing at somebody else's comment. I'm not laughing because you're on your third attorney. That's really good. So a lot of attorneys that are good will go after like facts. Like they'll be really good at producing facts, and that's really great. Like awesome, right? But also make sure this attorney researches like case law that protect you. We have a lot of our laws that protect us are so much more powerful than any law that could go after the other parent, right? Like if your ex is a total jerk and they freaking sent you harassing text messages and they're late picking up your kids and they're rude and they trash you on Facebook and their new partner is mean to you, those are really good facts, but do they have good laws to protect you? We're not really legally protected against someone being a jerk to us unless we want to get a restraining order. But someone just being a difficult person, someone being uncooperative, someone being unwilling to co-parent, attorneys will often go after those facts. And there's nothing legal that really help us. Like when parents want to get their kids back, oftentimes they'll go to court and they'll be like, my ex doesn't co-parent very well, or my ex sucks at co-parenting. They're not cooperative. They don't work with me, blah, blah, blah. That's great. But does that really help you get your kids back? Or is that just going to make the judge punish your ex for being a jerk? Are you after getting your ex a spanking, or do you want your kids back? So if your attorney also knows laws that are protective of you, that will insulate you from more abuse and government, because the court is our enemy. Everybody thinks the ex is so bad. The ex is just a little puppet, okay? The ex is just the little crash test dummy that's involved, that's asking for things, but it's the government that's doing all the bad things to you. Your ex didn't take your kids away from you. The state did. So it's really the state that we need to be protecting ourselves from. Your ex doesn't have a lot of power. The only thing your ex could ever do is lie in court, inflame the judge and make the judge not like you. That's what your ex is capable of doing. But being liked by a judge isn't needed for us to be parents. We don't need to be liked by anybody. You could literally if there's 7 billion people on the planet, you could be disliked by 6.99999 billion people and still have rights to your kids. You could even not be liked by your own kids and still have the right to be with your kids. So being liked, getting on the judge's good side, making the judge not like your ex, there's not really much legal stuff to protect you, So if your attorney is really good, make sure they're also good at researching case law that protect you. So someone says, I just caught my ex and the therapist in the middle of committing insurance fraud with reunification. Holy crap. We see that all the time. Oh my gosh. I reported to the insurance commission. They are now both under investigation in 2 states. Yes. My husband and I have been all over this for years. We want to blow this open. There is more insurance fraud in family courts than yeah. This needs to be covered. Yeah, you just inspired me to create an episode on that alone. So someone here, they can force you to go, but they can't force you to spiel or speak. So, I'm sorry. I'm really bad at reading through typos. They can force you to go, but they can't force you to speak. I think that's so amazing. I did a live stream probably 3 months ago on that, where if the parent is forced to see the psych eval, or forced to go to the psych eval anyway, or forced to, how to, I'll link that live stream in the comments. But yeah, I want to see a parent just sit there and not say anything, yeah. So someone says here, problem is some parents sell the formula, especially low income. Ooh, interesting. God, that's messed up. Freaking, yeah, selling the baby formula on Craigslist or something. Sua sponte, someone said. Someone answered with emojis. That's really hilarious. I filed a motion for parenting time and the judge ordered no contact that was not requested. Ooh, okay. So you filed a motion for parenting time. So you're basically saying, I want parenting time, give it to me. And the judge ordered a no contact that was not requested. So I'm assuming the no contact was against you, so you can't contact your own kids. So that sounds like a restraining order, right? So the judge issued a restraining order. So this is just what I would do. It's not legal advice. I would go back to court and say, I need to, I would file a motion to vacate that no contact order and say, this here is a de facto restraining order. So that's DEFACTO, de facto. Say, this is a de facto restraining order. No one filed for a restraining order, right? Because the other side didn't ask for the no contact order, right? So if you're asking for parenting time and the judge is just like, well, you can't see your kids anymore. Did the other side ask for a no contact order? So that's my first question to you. And if they did ask for a no contact order, did you get time to formulate a defense? In other words, did the ex ask for that right there in court and the judge just gave it to them without you having a chance to hire an attorney or do your research or anything? Or did the judge just freaking off the cuff issue a no contact order because that's in the best interest of your children? So that would be my question to you. And I had a parent 2 years ago have their no contact order vacated on that basis. The judge gave a sua sponte no contact order, and the parent went back like a week later and had the whole order thrown out, which is amazing. It's so incredible when parents get results in the court system. So that's what I would do. And it's relief not requested. Absolutely. And you weren't served with enough notice so that you could procure an argument. Does your course help with fighting the state? So the course covers like foundational things, and module 4 does go deep into that. I personally, this is just my opinion, I think it's much easier to fight the state in CPS cases than in family cases, because and most people are like, "What? You're crazy." The penalties are harsher in CPS court because your kids could wind up in foster care. At least in family court, if you lose, you're still probably most likely able to still have contact with your kids. Whereas if your kids are in foster care, it's just much harder. Like I'd rather my child be with my ex than in foster care, obviously. But I find that parents, the parents who I've worked with have had more success in CPS than the parents that I work with in family court. And the reason for that is because CPS has really strict laws that they have to abide by, and family court has no laws. There's no laws in family court. It's best interest. That's the law. The law is the opinion of the judge. Okay, so how can opinion ever be a law? Apparently that can happen. Go to family court, you'll see an opinion be a law. In CPS court, the laws are structured, they're outlined, they're bulleted. It's harder for the state to do what they want to do. The problem with CPS court is that the stakes are higher. The parents panic more. They get more and more freaked out, and they almost always give away their rights. They don't realize they're doing it. I'd say 95% of parents in CPS court give away their rights before they even see a judge. And so that's why we have so many kids in foster care, because parents don't understand that they agree to it because they feel like, oh my God, if I don't agree to this, then I'm going to freaking lose my kids. Like they're more and more scared in CPS court. And so that's how CPS has been so successful, because they use fear as their currency, because they can't sell services. They can't sell services like marketing them like someone like I would. So they have to use fear to get you to get their services. So fear is their currency. So someone just said no. I'll have to find the timestamp and find out what I said to make you say that. The other side lied and said I violated his previous order by lying. Okay. He got pissed off and ordered no contact. In the order, he wrote best interest of the children. Holy crap. So this looks like it was an order issued by the judge based on the judge's personal opinion of your kid's best interest. Well, your judge, is your judge the other parent to your children? Like, is your judge your ex? Because if not, if you didn't produce children with this person, then the judge has no say in coming in and inserting themselves to take over your child's best interest, because that's the parent's job. So I would vacate that order. I mean, that sounds some crazy stuff. That's not cool. Because the other thing they did was it's a de facto restraining order. Based on what I'm looking at, I'm not an attorney, but this, based on what I'm reading, it looks like a de facto restraining order, and you never had a restraining order hearing. And it also looks like a de facto termination of parental rights, a TPR, a no contact order. How is that any different than a TPR? How, like, until when? For another year, 2 years? Like, when does this no contact order expire? Is there an expiration date, or is it just no contact, goodbye, get out of my courtroom? Because if it's just a no contact order, and there's a full stop, then that's a freaking termination of parental rights. That's a de facto TPR. And you never got a TPR hearing, which requires clear and convincing evidence, according to Santosky versus Kramer. So if I were you, I'm not an attorney, this isn't legal advice, but if I were you, okay, so I would, it's a temporary order. God, that's unbelievable. So this is what these judges do, guys. They issue these no contact orders. They say you can't have any contact with your kids. They call it a temporary order so that the parent can't appeal. And then when the parent finally gets that permanent order, the judge will say, well, we already have this temporary order. The kids are clearly doing okay with this order, and we're going to make that order permanent. So that's how they terminate parental rights without actually terminating parental rights. It's very, very dangerous. And so this is a de facto restraining order and you never got a restraining order hearing. So you can, there's a lot of information. Like, I don't know if you are familiar with fixedfamilycourts.com, but you can research their materials and learn about all these things. They have a green book called Not in the Child's Best Interest. It's on Amazon. It's really good, and it's $35. Gosh. Okay, so you appealed and it was denied, and it was probably denied because it was a temporary order. Unbelievable. Jeez, this stuff just makes me mad. Like, I'm getting hot. So, yeah, just such a disgusting system, right? We're going to have to make a lot of noise to change the system. And so next week, we're going to be talking about the mom. Sorry, that's my daughter. Hang on, sweetheart. Okay, I'll get you some food, okay? I have to feed her. So she's getting hungry. So we're going to be talking about the mom, the doctor mom who had her daughter taken from her for not wearing a mask. And we need your help in sharing this information everywhere, because we want to embarrass these people who did this. And that's the only way we're going to get anyone's attention, unfortunately. So I'm going to be ending here because my daughter was very patient for an hour. And we'll meet up next Monday. Okay. So thanks so much for coming on. I appreciate the full house tonight. And we will meet up next week. Okay. Have a good night.
Are you all done?